Question 1. Under the Uniform Securities Act, what is the correct order of registration for a security using the coordination method? Is it A. The state administrator is required to personally conduct a full merit review and certify in writing that the offering price is fair and equitable before any coordinated sale may proceed? B. The security is registered solely at the state level under a self-contained state filing, and no registration statement is ever filed with the SEC under the Securities Act of 1933. C. Registration becomes effective the very instant the application is delivered to the administrator's office, with no coordination whatsoever with the federal registration statement's effective date. D. A federal registration statement under the Securities Act of 1933 is filed simultaneously with the state, and state effectiveness is coordinated with the SEC? The correct answer is D. Registration by coordination is used when a security is registered federally under the Securities Act of 1933 at the same time as the state filing. State effectiveness is timed to coincide with SEC effectiveness. The administrator never passes on the merits of an offering. Question 2. An agent registered in State A takes an unsolicited order from a client who is vacationing in State B, where the agent is not registered. Which statement is most accurate? Is it A. The agent is required to immediately obtain full registration in State B and pay all applicable state fees before accepting even a single unsolicited order from the vacationing client? B. The transaction may be permissible under a limited exemption for existing clients temporarily present in another state? C. The client is required to open an entirely new brokerage account domiciled in State B before any order originating there can be treated as lawful under the Act. D. The transaction is always strictly prohibited because the agent holds no registration in State B, regardless of where the client ordinarily resides or maintains the account? The correct answer is B. An agent typically must be registered where the client is located, but limited exemptions exist for transactions with existing clients who are only temporarily present in another state. The order being unsolicited and the client's transient presence are relevant factors. This narrow relief prevents technical violations during travel. Question 3. Which of the following is considered an exempt security under the Uniform Securities Act? Is it A. A general obligation bond issued by a municipality? B. A sale to an insurance company? C. A private placement sold to 40 non-institutional buyers? D. An unsolicited transaction by an existing customer? The correct answer is A. A municipal general obligation bond is an exempt security because of the nature of the issuer. The other choices describe exempt transactions, which relate to how or to whom a security is sold rather than the security itself. Distinguishing exempt securities from exempt transactions is a core Series 66 concept. Question 4. An investment advisor representative learns material non-public information about a public company from a client who is a corporate insider. The IAR then buys the stock for personal gain. This conduct is best described as, is it A. A prohibited practice constituting insider trading? B. An exempt transaction because it was unsolicited? C. A permitted use of client-provided research? D. Acceptable if the IAR discloses it in the next ADV update? The correct answer is A. Trading on material non-public information is prohibited regardless of how the information was obtained. No disclosure or exemption cures the violation. The IAR breached both securities law and fiduciary duty by placing personal interest ahead of the duty to the market and clients. Question 5. Under the Uniform Securities Act, which person would most likely need to register as an agent? Is it A. An administrative assistant who merely schedules client meetings and maintains the office calendar without ever soliciting or effecting any securities transaction? B. A back-office clerk who only processes and files completed trade confirmations and account statements and never communicates with the investing public about securities? C. An individual employed by a broker-dealer to solicit securities transactions from the public for compensation? D. An officer of the issuer who sells the issuer's exempt securities to the public but receives no commission or other special remuneration for those sales? The correct answer is C. An agent is an individual who represents a broker-dealer or issuer in effecting securities transactions. The person soliciting transactions from the public for a broker-dealer meets the definition. Clerical and ministerial employees who do not solicit or effect trades are generally excluded. Question 6. Which of the following professionals would most likely qualify for the exclusion from the definition of investment advisor because advice is incidental to their practice and no special compensation is received? Is it A. An individual who manages discretionary accounts for a wrap fee? B. An accountant who occasionally comments on the tax effect of an investment while preparing a return? C. A person whose sole business is publishing a paid stock-picking newsletter with specific client advice? D. A financial planner who charges a fee for creating investment plans? The correct answer is B. The Investment Advisors Act excludes certain professionals, lawyers, accountants, engineers, and teachers, when advice is incidental to their profession and no special compensation is received. An accountant commenting on tax effects during return preparation fits this late exclusion. Charging separately for investment advice defeats the exclusion. Question 7. A federal covered investment advisor with clients in 5 states is generally subject to registration and oversight primarily by, is it A. No securities regulator at any level, because a federal covered advisor is entirely exempt from oversight once it crosses the federal threshold? B. The SEC, though states retain anti-fraud authority? C. Each and every individual state in which the advisor happens to have even a single advisory client, on a full registration basis? D. Only the single state in which the advisor maintains its principal office and place of business, to the complete exclusion of the SEC? The correct answer is B. A federal covered advisor registers with the SEC rather than with individual states. However, states retain anti-fraud jurisdiction and can require notice filings and fees. This preserves state enforcement power while avoiding duplicative registration. Question 8. An agent tells a customer, this stock is guaranteed to go up because the state administrator approved the registration. This statement is it A. A prohibited misrepresentation of the effect of registration? B. Permissible so long as the statement is made only to accredited investors who meet the applicable income or net worth qualifications? C. Entirely accurate, because effectiveness of a state registration does in fact signify that the administrator has approved the security's merits. D. A lawful and ordinary description of the process of registration by qualification as it is conducted at the state level? The correct answer is A. Registration with the administrator never means the state approved the merits or guaranteed the security. Implying that registration ensures profit is a material misrepresentation and a prohibited practice. Agents must not misstate the effect of registration. Question 9. Which of the following is an exempt transaction under the Uniform Securities Act? Is it A. An isolated non-issuer transaction not effected through a broker-dealer? B. A general solicitation directed to 100 retail investors located within the administrator's own state, each contacted by mail? C. A solicited retail sale of open-end mutual fund shares to an individual customer at that customer's private residence? D. A public offering of newly issued common stock distributed to the public through registration by qualification at the state level? The correct answer is A. An isolated non-issuer transaction is a classic exempt transaction because it is a one-off sale not part of a regular business. Exempt transactions depend on the manner of sale rather than the security's identity. Public retail offerings and general solicitations do not qualify. Question 10. The state administrator may deny, suspend, or revoke the registration of an agent if the agent, is it A. recommends an investment product that the administrator happens to personally dislike, even though the recommendation was otherwise entirely suitable? B. Has been convicted of a securities-related felony within the past 10 years. C. Chooses to work simultaneously for more than one broker-dealer while maintaining proper and current registration with each of those firms. D. Earns an unusually high level of commissions during a given calendar year while servicing a book of satisfied and well-informed clients. The correct answer is B. The administrator may take disciplinary action for enumerated causes, including a securities-related felony conviction within the prior 10 years. High commissions or personal preference are not statutory grounds. Registration actions must be based on cause and are subject to notice and hearing rights. Question 11. Under NASAA Model Rules on Custody, an investment advisor that has custody of client funds or securities generally must, is it A. Take affirmative steps to avoid any surprise examination by an independent accountant so as to keep the custody arrangements confidential. B. Maintain the assets with a qualified custodian and arrange for account statements to be sent to clients. C. Commingle the client's cash together with the advisor's own operating funds in a single account for administrative efficiency and convenience. D. Hold all client security certificates in the advisor's personal safe deposit box rather than with any third-party financial institution. The correct answer is B. NASAA custody rules require use of a qualified custodian and delivery of account statements to clients, often supplemented by a surprise examination. Commingling client and firm assets is prohibited. These safeguards protect clients against misappropriation. Question 12. A broker-dealer with no place of business in a state deals exclusively with which type of client and may qualify for an exemption from registration in that state? Is it A. Retail clients who were first referred to the firm through local newspaper and radio advertising placed within that particular state? B. Retail walk-in customers who visit the firm's premises even though the firm maintains no place of business in the state? C. Institutional clients such as other broker-dealers and banks. D. First-time individual investors who have never previously held or maintained a brokerage account anywhere in the country? The correct answer is C. A broker-dealer with no place of business in the state may be exempt from registration if it deals only with institutional clients, other broker-dealers, or issuers. Dealing with retail customers in the state generally triggers registration. The exemption is designed for limited, professional-to-professional activity. Question 13. Under the Investment Advisors Act, an advisor's brochure, Form ADV Part 2, must be delivered to a client. Is it A. Never, because Form ADV Part 2 is a confidential regulatory filing that is not shared with advisory clients? B. At or before entering into the advisory agreement, with annual updates offered? C. Only after the client has lodged a formal written complaint about the advisor's services, fees, or performance? D. Only to institutional clients such as banks and insurers, and never to any individual retail advisory client? The correct answer is B. The brochure rule requires delivery of Form ADV Part 2 at or before entering into the advisory contract, with an annual delivery or offer of an updated brochure. This ensures clients receive material disclosures about the advisor's business, fees, and conflicts. It is a cornerstone of the fiduciary disclosure framework. Question 14. An investment advisor wants to enter a contract that assigns the advisory agreement to another firm following a merger. Under the Uniform Securities Act, assignment of an advisory contract generally requires, is it A. Approval solely by the administrator? B. No client involvement whatsoever? C. Consent of the client? D. Only a notice filing with the SEC? The correct answer is C. An advisory contract may not be assigned without the client's consent. This protects the personal nature of the advisory relationship. A change in control of the advisor may also constitute an assignment requiring consent. Question 15. Which of the following best describes a fiduciary obligation that an investment advisor owes but a broker-dealer historically did not owe under a pure suitability standard? Is it a fiduciary duty that is owed exclusively to large institutional clients and never extends to any individual retail advisory customer? B. A duty to affirmatively guarantee a minimum level of investment performance and to reimburse the client for any market losses. C. A duty limited to ensuring that a single transaction is not unsuitable at the precise point of sale, with no continuing obligation. D. An ongoing duty of loyalty and care requiring the advisor to place the client's interest first and disclose all material conflicts? The correct answer is D. An investment advisor is a fiduciary with continuing duties of loyalty and care, including full disclosure of material conflicts and placing the client's interest first. A historical suitability standard focused on whether a specific recommendation was suitable at the moment of sale. No advisor can guarantee performance. Question 16. An agent churns a client's account. This unethical practice is best defined as, is it a, prudently diversifying a client's holdings across multiple asset classes in accordance with the client's stated objectives? B. Excessive trading designed to generate commissions rather than to benefit the client. C. Rebalancing a client's portfolio approximately once per year to restore the agreed-upon strategic asset allocation. D. Recommending long-term buy-and-hold securities that generate comparatively little commission revenue for the agent. The correct answer is B. Churning is excessive trading in a customer's account driven by the agent's desire for commissions rather than the client's interests. It is a prohibited practice regardless of whether individual trades are suitable. Frequency and cost relative to the client's objectives are key indicators. Question 17. Under the Uniform Securities Act, the term security would not typically include, is it a fixed payment whole life insurance policy? B. A share of common or preferred stock issued by a domestic operating corporation to its investors? C. A note, bond, debenture, or other evidence of corporate indebtedness sold to public investors? D. An investment contract under the Howey test in which investors expect profits from the efforts of others? The correct answer is A. A fixed, guaranteed whole life insurance policy and fixed annuities are generally excluded from the definition of a security. Investment contracts, notes, bonds, and stock are securities. Variable products, by contrast, are securities because of investment risk borne by the holder. Question 18. An agent shares in the profits and losses of a customer's account. Under NASAA standards, this is permitted only if, is it a, the agent shares proportionally in the account's gains and losses without obtaining any written approval from the firm or the customer. B. The customer merely gives a verbal agreement at the point of sale, with no written authorization from the employing broker-dealer. C. The customer and the broker-dealer give written consent and sharing is proportional to the agent's own contribution. D. The account happens to earn a net profit for the particular calendar quarter in which the sharing arrangement is in effect. The correct answer is C. Sharing in a customer account is prohibited unless the agent obtains written authorization from both the customer and the broker-dealer, and shares only in proportion to the agent's financial contribution. Verbal agreement alone is insufficient. This rule limits conflicts of interest. Question 19. A client sends an unsolicited written complaint to an agent alleging unauthorized trading. The agent should, is it A, destroy the written complaint letter as quickly as possible in order to avoid any further escalation of the underlying dispute? B. Ignore the complaint entirely unless the client repeats the same allegation in writing on at least 3 separate occasions. C. Personally settle the matter directly with the client using firm funds, without providing any notice to a supervisor. D. Promptly forward the complaint to a designated supervisor or compliance for handling and record-keeping? The correct answer is D. Written customer complaints must be promptly forwarded to the firm's designated supervisor or compliance for review and record-keeping. Agents may not conceal, destroy, or unilaterally settle complaints. Proper handling protects both the client and the firm's compliance obligations. Question 20. Under the Investment Advisors Act, a performance-based fee that charges a share of capital gains is generally permitted only when the client is it a client who is under the age of 21 at the time the performance-based advisory fee arrangement is first entered into. B. Any retail client at all, provided the client simply signs a written waiver acknowledging the performance fee arrangement. C. A qualified client meeting minimum net worth or assets under management thresholds. D. A first-time investor who is opening a securities advisory relationship for the very first time in his or her life. The correct answer is C. Performance-based compensation is generally prohibited unless the client is a qualified client meeting net worth or assets under management thresholds. This protects less sophisticated investors from fee structures that could encourage excessive risk-taking. A signed waiver alone does not qualify a retail client. Question 21. The administrator may issue a cease and desist order. Is it a only after the respondent has first been criminally convicted of a felony related to the securities business? B. Only after first obtaining the express written consent of the Securities and Exchange Commission in Washington. C. With or without a prior hearing to prevent a violation of the Act. D. Only against federal covered investment advisors, and never against a state-registered broker-dealer or agent? The correct answer is C. The administrator has authority to issue cease and desist orders, and may do so with or without a prior hearing when necessary to prevent an ongoing or imminent violation. This is a preventive administrative power. It does not require a criminal conviction first. Question 22. An IAR recommends a securities transaction that will generate a large commission for the IAR's affiliated broker-dealer. To act ethically, the IAR must at minimum, is it A, disclose the conflict of interest so the client can make an informed decision. B, increase the client's advisory fee by a corresponding amount in order to offset and neutralize the underlying conflict of interest. C, deliberately avoid mentioning the compensation arrangement to the client so as to keep the client calm and unconcerned. D, cancel the recommended transaction entirely, since any commission-generating trade is automatically impermissible for an IR? The correct answer is A. A fiduciary must disclose material conflicts of interest, such as additional compensation to an affiliate, so the client can evaluate the recommendation. Concealment violates the duty of loyalty. Disclosure, not necessarily cancellation, is the baseline requirement, though the recommendation must still be in the client's best interest. Question 23. Which of the following is generally an exempt security under the Uniform Securities Act? Is it A, security issued by a bank organized under U.S. law? B, a newly issued penny stock aggressively offered to retail clients through cold calling campaigns across the state? C, a limited partnership interest in a speculative venture that is sold to members of the general investing public? D, a promissory note issued by an early-stage startup and sold door-to-door to first-time individual investors? The correct answer is A, securities issued by banks are exempt securities under the Act because of the regulated nature of the issuer. Public limited partnership interests, speculative promissory notes, and penny stocks are not automatically exempt. The exemption rests on issuer characteristics. Question 24. An agent guarantees a customer against loss on a stock recommendation to close the sale. This practice is it A, prohibited because agents may not guarantee customers against loss? B, affirmatively required by the suitability rule whenever a recommendation carries a meaningful degree of market risk? C, fully permitted so long as the guarantee against loss is reduced to writing and signed by the agent and customer? D, permitted whenever the customer happens to qualify as an accredited investor under the applicable income test? The correct answer is A, agents and broker-dealers may not guarantee a customer against loss. Such guarantees misrepresent the risk of investing and are a prohibited practice. Putting the guarantee in writing does not make it permissible. Question 25. Under the Uniform Securities Act, The statute of limitations for a purchaser to bring a civil suit for a violation is generally, is it a short window of only 30 calendar days measured from the date the security was originally sold to the buyer. B. A flat 10 years measured from the date of sale, running regardless of when the buyer discovered the violation. C. The earlier of 2 years after discovery or 3 years after the sale, subject to state variation. D. Unlimited in duration, so that a purchaser may bring a civil action at any time no matter how long ago the sale occurred. The correct answer is C. Civil liability suits are generally subject to a statute of limitations tied to discovery of the violation and the date of sale, commonly framed as 2 years after discovery or 3 years after the transaction, subject to state adoption. This limits stale claims. Exact periods can vary by state enactment. Question 26. A remedy available to a defrauded purchaser under the civil liability provisions of the Act typically allows recovery of, is it A. Automatically triple the original purchase price of the security, awarded as a matter of right in every proven case. B. Punitive damages in all cases, imposed upon the seller to punish and deter future violations of the securities laws. C. Only the future lost profits the purchaser would have earned had the security performed as the seller had represented. D. The consideration paid plus interest, costs, and attorney fees, less any income received. The correct answer is D. The civil liability provision generally allows a purchaser to recover the amount paid plus interest at a specified rate, court costs, and reasonable attorney fees, reduced by any income already received. Automatic treble or punitive damages are not the standard remedy. The measure is designed to make the buyer whole. Question 27. An investment advisor exercises discretion in a client account. Under the Uniform Securities Act, this generally requires, is it A. A written performance guarantee assuring the client of a minimum rate of return on the discretionary account. B. Nothing at all beyond an informal verbal understanding reached between the advisor and the client at account opening. C. Prior written discretionary authority from the client. D. Only the prior written approval of the state administrator, obtained before any discretionary trade may be entered. The correct answer is C. Exercising discretion in a client's account requires written discretionary authorization from the client. For investment advisors, oral discretion may be permitted for a limited initial period regarding price and time only, but full discretion needs written authority. This protects clients from unauthorized transactions. Question 28. NASAA's model rule on unethical business practices of investment advisors would consider which of the following a violation? Is it A. Borrowing money from a client who is not a lending institution or affiliate? B. Fully disclosing all advisory fees and charges within the written advisory contract before it is signed by the client. C. Delivering the required disclosure brochure to the client at or before entering into the written advisory contract. D. Rebalancing a client's portfolio strictly in accordance with the client's own previously stated investment policy. The correct answer is A. Borrowing money or securities from a client is an unethical practice unless the client is in the business of lending, such as a bank, or is an affiliate. It creates a serious conflict of interest. Proper fee disclosure and policy-based rebalancing are appropriate conduct. Question 29. Which threshold generally determines whether a mid-sized advisor registers with the SEC rather than the states? Is it A. The total number of employees the advisory firm maintains, counted entirely without any regard to assets under management? B. Assets under management crossing a regulatory threshold, with $100 million as a key dividing line under federal rules. C. The size of the advisor's annual marketing and advertising budget relative to that of competing advisory firms. D. The total number of years the advisor has been continuously in business under its current ownership and firm name. The correct answer is B. Assets under management determine federal versus state registration, with $100 million as a key dividing line for many advisors, and $110 million as the point requiring SEC registration, plus buffer rules. Below the threshold, an advisor is generally state registered. Employee count and marketing budget are not the test. Question 30. An agent effects a transaction that is not recorded on the books of the employing broker-dealer, without the firm's knowledge or authorization. This is best described as, is it a fully permitted private transaction that an agent may lawfully conduct outside of the employing firm's supervision? B. Selling away, a prohibited practice. C. Registration of securities by qualification at the state level as described in the Uniform Securities Act. D. Registration of securities by the coordination method used in conjunction with a federal registration statement. The correct answer is B. Selling away is when an agent effects private securities transactions outside the employing broker-dealer's supervision and records without authorization. It is prohibited because it evades supervision and firm oversight. Agents must have firm approval and, where required, record-keeping. Question 31. The definition of sale or offer to sell under the Uniform Securities Act generally includes, is it a bona fide gift of non-assessable stock? B. A bona fide pledge of securities as loan collateral. C. A gift of assessable stock. D. A stock dividend where no consideration is given? The correct answer is C. The Act treats a gift of assessable stock as a sale because the recipient may owe future assessments, constituting value. Bona fide gifts of non-assessable stock, stock dividends, and collateral pledges are generally not sales. These definitional nuances affect when the Act applies. Question 32. An administrator's authority to conduct investigations and subpoena witnesses generally extends to conduct that, is it a, involves only federal covered securities and never touches any security that is registered at the state level. B. Bears no connection whatsoever to the state, its residents, or any offer made or accepted within its borders. C. Occurs strictly and entirely within the administrator's own state and nowhere else, with no interstate element at all. D. Originates in, is directed to, or is accepted within the state, even across state lines. The correct answer is D. The administrator has jurisdiction over an offer or sale that originates in, is directed into, or is accepted within the state. This includes cross-border activity touching the state. The administrator may investigate and subpoena to enforce the act within that jurisdictional reach. Question 33. A broker-dealer wishes to withdraw its registration. Under the Uniform Securities Act, withdrawal generally becomes effective, is it a, only after a mandatory waiting period of 5 full years has elapsed from the date on which the withdrawal was filed. B. Only upon obtaining the express prior approval of the Securities and Exchange Commission in addition to the state. C. 30 days after filing, unless the administrator institutes a proceeding. D. Immediately upon the mere filing of the withdrawal request, with no waiting period of any kind ever applying at all. The correct answer is C. A withdrawal of registration typically becomes effective 30 days after filing, provided no revocation or other proceeding is pending or instituted. The administrator retains authority to act on violations for a period after withdrawal. This orderly process protects investors during transitions. Question 34. An advisor engages in an agency cross-transaction, arranging a trade between two of its advisory clients. To do this properly, the advisor generally must, is it a, obtain client consent, disclose its role and any compensation, and not recommend the transaction to both sides. B. Guarantee both advisory clients a profit on the cross-transaction before it may lawfully be arranged and executed. C. Never disclose the arrangement to either client so as to preserve the confidentiality of the firm's trading strategy. D. Charge a performance-based fee to each participating client in order to compensate the advisor for the arrangement. The correct answer is A. Agency cross-transactions require written client consent, disclosure of the advisor's role and compensation, and the advisor generally may not have recommended the trade to both parties. These safeguards address the conflict of representing both sides. Annual statements of cross-transactions are also required. Question 35. Under the Uniform Securities Act, the least intrusive method of state registration for a well-established issuer with a strong track record filing a federal statement is it A, registration completed purely at the state level without any accompanying federal registration statement being filed? B, registration by qualification, the most demanding and disclosure-intensive method available under the Act. C, a door-to-door offering conducted directly with individual retail investors throughout the administrator's state. D, notice filing for a federal covered security? The correct answer is D, federal covered securities, such as those listed on major exchanges or certain investment company shares, are subject only to state notice filings and fees rather than full state registration. Qualification is the most burdensome method used when no federal registration exists. Notice filing is the least intrusive for covered securities. Question 36. An agent recommends a security to a client without any reasonable basis to believe it is suitable, simply to meet a sales quota. This conduct, is it A, entirely acceptable, because meeting internal sales quotas is a legitimate and ordinary business objective for the firm? B, fully permitted whenever the security being recommended happens to be exempt from registration under the Act? C, exempt from any suitability obligation whenever the client happens to be a wealthy or high net worth individual? D, violates the agent's obligation to have a reasonable basis for recommendations? The correct answer is D, recommending securities without a reasonable basis for suitability is a prohibited practice, regardless of sales quotas or the client's wealth. Agents must consider the client's financial situation, objectives, and needs. Quotas never justify unsuitable recommendations. Question 37. Which of the following persons is excluded from the definition of broker-dealer under the Uniform Securities Act? Is it A, a firm making a market in over-the-counter stocks for state residents? B, an agent, issuer, or bank acting within the statutory exclusions? C, a dealer with a branch office in the state? D, a firm soliciting retail securities orders in the state? The correct answer is B. The definition of broker-dealer excludes agents, issuers, and banks, savings institutions, and trust companies. These persons are regulated under other provisions or excluded by policy. Firms soliciting or making markets for state residents generally are broker-dealers requiring registration. Question 38. Under NASAA Model Record-Keeping Rules, a state-registered investment advisor must generally preserve required books and records for a minimum of, is it A, 5 years, with the first 2 years in an easily accessible location? B, 1 single year measured from the end of the fiscal year in which the record was originally created by the advisor? C, 2 years in total, with the records kept in any location the advisor reasonably chooses at its own discretion? D, 6 months from creation, after which the advisor may lawfully destroy the required books and records entirely? The correct answer is A, state-registered advisors must generally keep required records for 5 years, with the most recent 2 years readily accessible, often at the principal office. This ensures records are available for examination. Shorter periods do not meet the model rule. Question 39. An agent commits fraud in connection with the sale of a security that is itself exempt from registration. Under the Uniform Securities Act, the anti-fraud provisions, is it A, apply only if the defrauded client happens to be a resident of the administrator's own state at the time of the sale? B, do not apply at all, because the exempt status of the security also exempts the transaction from the anti-fraud rules. C, still apply, because anti-fraud provisions apply to exempt and non-exempt securities alike. D, apply exclusively to federal covered securities and never to a security that is exempt at the state level? The correct answer is C. The anti-fraud provisions of the Act apply to all securities transactions, including those involving exempt securities and exempt transactions. Exemption from registration never exempts a person from the duty not to commit fraud. This is a frequently tested distinction. Question 40. An IAR wishes to advertise using a client testimonial. Historically, under NASAA and advisor rules, the treatment of testimonials has been, always freely permitted with no conditions whatsoever, so long as the quoted client actually made the statement. B. Restricted or requiring specific conditions and disclosures to avoid being misleading. C. Affirmatively required in every single advertisement an IAR disseminates to the investing public within the state. D. Prohibited only for broker-dealers and their agents, while investment advisors may use them without any limits. The correct answer is B. Advisor advertising involving testimonials has historically been restricted and, where permitted under updated marketing rules, requires clear disclosures to prevent misleading impressions. Unconditioned use risks being deceptive. Advisors must ensure advertising is not false or misleading in any respect.